Hello dear friends. Today we are starting the audiobook from page 54, Part C, Issue of Securities. Equity shares with differential voting rights. While Section 43 enables companies to issue equity shares with differential rights as to dividend, voting rights, etc., Rule 4 of the Company's Share Capital and Divengers Rules 2014 states the conditions regarding shares with differential voting rights. Further, Rule 3 states that the provisions of these rules shall apply to 1. All unlisted public companies, 2. All private companies, and 3. Listed companies so far as they do not contradict or conflict with any of other regulations framed in this regard or by the Securities and Exchange Board of India. Conditions for issuing shares with differential rights. Rule 4 of the Company's Share Capital and Divenger Rules 2014. Only a company limited by shares can issue equity shares with differential rights as to dividend, voting or otherwise. Such company has to comply with the following conditions, namely: A. The Articles of Association of the company authorizes the issue of shares with differential rights. B. The issue of shares is authorized by an ordinary resolution passed at a general meeting of the shareholders. When the equity shares of a company are listed on a recognized stock exchange, the issue of such shares shall be approved by the shareholders through postal ballot. Though with Companies Amendment Act 2017 coming into force, any item of business required to be transacted by means of postal ballot may be transacted at a general meeting by a company which is required to provide the facility to members to vote by electronic means under Section 108. C. The voting power in respect of shares with differential rights of the company shall not exceed 74% of total voting power, including voting power in respect of equity shares with differential rights issued at any point of time. D. The company has not defaulted in filing financial statements and annual returns for 3 financial years immediately preceding the financial year in which it is decided to issue such shares. E. The company has no subsisting default in the payment of a declared dividend to its shareholders or repayment of its mature deposits or redemption of its preference shares or debentures that have become due for redemption or payment of interest on such deposits or debentures or payment of dividend. F. The company has not defaulted in payment of the dividend on preference shares or repayment of any term loan from a public financial institution or state-level financial institution or scheduled bank that has become repayable or interest payable thereon or dues with respect to statutory payments relating to its employees or any authority or default in crediting the amount in Investor Education and Protection Fund to the central government. A company may issue equity shares with differential rights upon expiry of 5 years from the end of the financial year in which such default was made good. G. The company has not been penalized by court or tribunal during the last 3 years of any offence under RBI Act 1934, the SEBI Act 1992, the Securities Contract Regulation Act 1956, the Foreign Exchange Management Act 1999, or any other special act under such companies being regulated by sectoral regulators. Disclosures in the explanatory statement to the notice of the meeting. While taking a decision, it is important that all information is provided with regard to the matter. Hence, Rule 4 Sub-Rule 2 of the Company's Share Capital and Divenger Rules 2014 requires that the explanatory statement shall be annexed to the notice of the general meeting or of a postal ballot. The explanatory statement shall contain the following particulars, namely: A. The total number of shares to be issued with differential right. B. The details of the differential rights. C. The percentage of the shares with differential rights to the total post-issue paid up equity share capital, including equity shares with differential rights issued at any point of time. D. The reasons or justifications for the issue. E. The price at which such shares are proposed to be issued, either at par or at premium. F. The basis on which the price has been arrived at. G. 1. In case of private placement or preferential issue, under that A. Details of total number of shares proposed to be allotted to promoters, directors and key managerial personnel. And B. Details of total number of shares proposed to be allotted to persons other than promoters, directors and key managerial personnel and their relationship, if any, with any promoter, director or key managerial person. And second point under G. In case of public issue, reservation, if any, for different classes of applicants including promoters, directors or key managerial personnel. H. The percentage of voting right which the equity share capital with the differential voting right shall carry to the total voting right of the aggregate equity share capital. I. The scale or promotion in which the voting rights of each such class or type of shares shall vary. J. The change in control, if any, in the company that may occur consequent to the issue of equity shares with differential voting rights. K. The diluted earnings per share pursuant to the issue of such shares calculated in accordance with the applicable accounting standards. And L. The pre- and post-issue shareholding pattern along with voting rights as per Regulation 31 of SEBI Listing Obligations and Disclosure Requirements Regulation 2015. Conversion of existing equity share capital into differential voting rights and vice versa, not possible. The company shall not convert its existing equity share capital with voting rights into equity share capital carrying differential voting rights and vice versa. Disclosures in the board's report. The board of directors are required to disclose the details of the issue of equity shares with differential rights in the board's report for the financial year in which it was completed. The details are given in lesson Transparency and Disclosure later in this study. Rights of holders of equity shares with differential voting rights. The holders of the equity shares with differential rights enjoy all other rights such as bonus shares, right shares, etc., which the holders of equity shares are entitled to, subject to the differential rights with which such shares have been issued. Rights of members to contain the details of equity shareholders having differential voting rights. When a company issues equity shares with differential rights, the register of members maintained under Section 88 shall contain all the relevant particulars of the shares so issued along with details of the shareholders. Procedure for issue of equity shares with differential voting rights. 1. Check whether the Articles of Association of the company authorizes issue of equity shares with the differential rights, and if not, the name and the Articles of Association of the company. 2. Hold the board meeting to issue the notice of general meeting for issuance of equity shares with the differential rights. 3. Before issuing equity shares with differential rights as to dividend, voting or otherwise, ensure that the conditions of issue are fully satisfied. 4. If the company is listed with any of the recognized stock exchange, then within 30 minutes of the closure of the aforesaid board meeting, intimate to the concerned stock exchange about the decision taken at the board meeting. 5. Pass the ordinary resolution in the general meeting or through postal ballot under Section 110 of the Act. 6. Once the company makes any allotment, then it shall, within 30 days thereafter, file with the registrar a return of allotment in form PAS 3 along with the fees as specified in the company's registration offices and fees rules 2014. 7. The company shall not convert its existing equity share capital with voting rights into equity share capital carrying differential voting rights and vice versa. 8. In case of listed company, send copies of the notice and a copy of the proceedings of the general meeting to the stock exchange within 24 hours of the occurrence of event. This is mentioned in Regulation 36 of SEBI Listing Obligation and Disclosure Requirements 2015. 9. Complete all the other proceedings for the issue of certificate of shares with differential voting rights, making necessary entries in various registers. In case of a company whose shares are dematerialized form, inform the depositories about the same for credit to the respective accounts. 11. Intimate the details of allotment of shares to the depository immediately on allotment of such shares. 12. Maintain the register of members under Section 88 containing all the relevant particulars of the shares so issued along with the details of shareholders. Issue and redemption of preference shares. Company cannot issue irredeemable preference shares or redeemable preference shares with the redemption beyond 20 years. Subsection 1 of Section 55 states that no company limited by shares shall issue any preference shares which are irredeemable. Subsection 2 of Section 55 further states that a company limited by shares may, if so authorized by its articles, issue preference shares which are liable to be redeemed within a period not exceeding 20 years from the date of their issue, subject to such conditions as may be prescribed. Exceptions: issue and redemption of preference shares by company in infrastructure projects. A company engaged in the setting up and dealing with of infrastructural projects may issue preference shares for a period exceeding 20 years but not exceeding 30 years, subject to the redemption of a minimum 10% of such preference shares per year from the 21st year onwards or earlier on proportionate basis at the option of the preference shareholders. The term infrastructure project means the infrastructure project specified in Schedule 6. Other conditions are attached. Proviso to subsection 2 of Section 55 states that a. Preference share shall be redeemed out of the profits of the company which would otherwise be available for dividend or out of the proceeds of a fresh issue of shares made for the purposes of such redemption. B. Such shares shall be redeemed only if they are fully paid. C. Where such shares are proposed to be redeemed out of the profits of the company, they shall out of such profits be transferred a sum equal to the nominal amount of the shares to be redeemed to a reserve to be called the Capital Redemption Reserve Account. Under D, there are 2 points. First point, in case of such class of companies as may be prescribed and whose financial statement comply with the accounting standards prescribed for such class of companies under Section 133, the premium, if any, payable on redemption shall be provided for out of the profit of the company before the shares are redeemed. Premium, if any, payable on redemption of any preference shares issued on or before the commencement of this Act by any such company shall be provided for out of the profits of the company or out of the company's securities premium account before such shares are redeemed. And the second point under D, in a case not falling under subclause 1 above, the premium, if any, payable on redemption shall be provided for out of the profits of the company or out of the company's securities premium account before such shares are redeemed. Subsection 3 of Section 55 states that when a company is not in a position to redeem any preference shares or to pay any dividend, if any, on such shares in accordance with the terms of issue, such shares herein referred to as unredeemed preference shares, it may, with the consent of the holder of 3/4 in the value of such preference shares and with the approval of the tribunal on a petition made by it in this behalf, issue further redeemable preference shares equal to the amount due, including the dividend thereon, in respect of the unredeemed preference shares, and on the issue of such preference or such further redeemable preference shares, the unredeemed preference shares shall be deemed to have been redeemed. The issue of further redeemable preference shares or the redemption of preference shares under this section shall not be deemed to be an increase or, as the case may be, a reduction in the share capital of the company. The capital redemption reserve account may, notwithstanding anything in this section, be applied by the company in paying up unissued shares of the company to be issued to members of the company as fully paid bonus shares. Prescriptions under company's share capital and Divenger rules 2014 with regard to issue and redemption of preference shares, that is Rule 9. Conditions. A company having a share capital may, if so authorized by its articles, issue preference shares subject to the following conditions, namely: A. The issue of such shares has been authorized by passing a special resolution in the general meeting of the company. B. The company at the time of such issue of preference shares has no subsisting default in the redemption of preference shares issued earlier or in payment of dividends due on any preference shares. A resolution authorizing preference shares to set out certain particulars. A company issuing preference shares shall set out in the resolution particulars in respect of the following matters relating to such shares, namely: A. The priority with respect to payment of dividend or repayment of capital compared to equity shares. B. Participation in surplus funds. C. The participation in surplus assets and profits on winding up which may remain after the entire capital has been repaid. D. The payment of dividend on cumulative or non-cumulative basis. E. The conversion of preference shares into equity shares. F. The voting rights. G. The redemption of preference shares. Explanatory statement to special resolution to set out certain particulars. While taking a decision, it is important that all information is provided with regard to the matter. Hence, Sub-Rule 3 of Rule 9 states that the explanatory statement to be annexed to the notice of the general meeting, which shall provide the material facts concerned with and relevant to the issue of such shares, including: A. The size of the issue and number of preference shares to be issued and the nominal value of each share. B. The nature of such shares, that is cumulative or non-cumulative, participating or non-participating, convertible or non-convertible. The object of the issue, that is the third point. D. The manner of issue of shares. E. The price at which such shares are proposed to be issued. F. The basis on which the price has been arrived at. G. The terms of issue, including terms and rate of dividend on each share, etc. H. The terms of redemption, including the tenure of redemption, redemption of shares at premium, and if the preference shares are convertible, the terms of conversion. I. The manner and modes of redemption. J. The current shareholding pattern of the company. K. The expected dilution in equity share capital upon conversion of preference shares. Register of members to contain the particulars of preference shareholders. When a company issues preference shares, the register of members maintained under Section 88 shall contain the particulars in respect of such preference shareholders. Redemption of preference shares. Sub-Rule 6 of Rule 9 states that a company may redeem its preference shares only on the terms on which they were issued or as varied after due approval of preference shareholders under Section 48 of the Act, and the preference shares may be redeemed: A. At a fixed time or on the happening of a particular event. B. Any time at the company's option. Or C. Any time at the shareholders' option. Procedure to issue and redemption of preference shares. First point, for issue of preference shares, the articles of the company should authorize for it. If not, then amendment in the articles of the company is required. Also, ensure that there is no subsisting defaults in redemption of preference shares earlier or in payment of dividend due on any preference shares. Second point, Ensure that the resolution for issuing preference shares contains all the relevant particulars as mentioned above. Point 3. Issue the notice of general meeting along with the explanatory statement to provide the required details. In case of listed entity, intimate the stock exchange at least 2 working days in advance of the date of board meeting. For this, we have to refer Regulation 29 of Listing Regulations. Point 4. Pass special resolution and file with the registrar Form MGT 14 along with the fees so specified in the company's Registration of Offices and Fees Rules 2014 within 30 days of passing the resolution. Note, in case of one-person company, for the purpose of passing of ordinary and special resolution in general meeting, any business which is required to be transacted at an annual general meeting or other general meeting of a company by means of an ordinary resolution or special resolution, it shall be sufficient if the resolution is communicated by the member to the company and entered in the minutes book and signed and dated by the member, and such date shall be deemed to be the date of meeting for all purposes under this Act. Point number 5. Within 30 days of allotment, while the registrar the return of allotment in Form PAS 3 along with fee as specified in Company's Registration of Offices and Fees Rules 2014. Point 6. Update the register of members maintained under Section 88 after issue of preference shares. Point number 7. The company may redeem the preference shares only on terms on which they were issued or as varied after due approval of preference shares. Point 8. The preference shares may be redeemed as given below. A. At fixed time or happening of a particular event. B. Any time at the company's option. C. Any time at the shareholder's option. 9th point. The notice of redemption of preference shares shall be filed by the company with the registrar in Form SH7 along with the altered MOA with the fees as specified in Company's Registration of Offices and Fees Rules 2014 within 30 days of redemption of preference shares. Point number 10. Once the allotment is made, the company shall file within 30 days of allotment, file with the registrar a return of allotment in Form PAS 3 along with the fees specified in Company's Registration of Offices and Fees Rules 2014. Point number 11. Deliver the share certificate of allotted shares within a period of 2 months from the date of allotment. And 12. Intimate the details of allotment of shares to the depository immediately on allotment of such shares. Remedies available for preference shareholders in relation to redemption of preference shares. The National Company Law Appellate Tribunal (NCLAT) in the matter of Bank of Baroda, that is an appellant, versus Aban Offshore Limited respondent held that intention of the legislature while promulgating Section 55 of the Companies Act 2013 was to compulsorily provide for redemption of preference shares by doing away with the issue of irredeemable preference shares. Therefore, even though there is no specific provision stipulated under the Companies Act 2013 through which relief can be sought by preference shareholders in case of non-redemption by the company or consequent non-filing of petition under Section 55 of the said Act, the intention of the legislature being clear and absolute, tribunal's inherent power can be invoked to get an appropriate relief by an aggrieved preference shareholder or holders. Alternatively, preference shareholders coming within the definition of members under subclause 55 of Section 2, read with Section 88 of the Companies Act 2013, may file a petition under Section 245 of the said Act as a class of action suit being aggrieved by the conduct of affairs of the company. Thereby, It was held that preference shareholders are not remediless, and for redemption of preference shares, they can file an application under subsection 3 of section 55 of the Companies Act 2013, or alternatively they may also file application under section 245 of the Companies Act 2013 as a class action suit and the NCLT while exercising the inherent power, that is Rule 11 of NCLT Rules 2016, can pass appropriate order. Further issue of share capital. This is explained under section 62, where at any time a company having a share capital proposes to increase its subscribed capital by the issue of further shares, to such shares shall be offered to A. holders of equity shares. This is described under clause A, subsection 1 of section 62, that is rights issue. B. employees. This is explained under clause B of subsection 1 of section 62, that is employee stock options, and any person, that is under preferential basis, explained under clause C subsection 1 of section 62. Now let us see how they are issued to persons who at the date of the offer are holders of equity shares of the company in proportion to the paid up share capital on those shares by sending letter of offer subject to such conditions as may be prescribed. Employees under scheme of employee stock option. Any persons, whether or not those persons include the persons referred to in clause A or B, if it is authorized by a special resolution, either for cash or for a consideration other than cash, if the price of such shares is determined by the valuation report of a registered valuer, subject to such conditions as may be prescribed. Conditions for further issue of shares to equity holders, rights issue, that is clause A, subsection 1 of section 62. The offer shall be made by notice, specifying the number of shares offered and limiting a time not being less than 15 days and not more than 30 days from the date of the offer, within which the offer, if not accepted, shall be deemed to have been declined, and the offer shall be deemed to include right of renunciation unless the articles of the company otherwise provide, and the notice referred above shall contain a statement of this right. If the offer is rejected by the equity shareholders after the expiry of the time specified in the notice aforesaid, or on receipt of earlier intimation from the person to whom such notice is given that he declines to accept the shares offered, the board of directors may dispose of them in such manner which is not disadvantageous to the shareholders and the company. The said notice shall be dispatched through registered post or speed post or through electronic mode or courier or any other mode having proof of delivery to all the existing shareholders at least 3 days before the opening of the issue. Unless the articles of the company otherwise provide, the directors must state in the notice of offer of rights shares the facts that the shareholders has also the right to renounce the offer in whole or in part in favor of some other persons. However, in case of a private company, case 90% of the members of private company have given their consent in writing or in electronic mode, the periods lesser than those specified in the subclause or subsection shall apply. Accordingly, time limit for acceptance of offer by existing shareholders may be less than 15 days if 90% of the members of a private limited company have given their consent either in writing or through electronic mode. If a shareholder has neither renounced in favor of another person nor accepted the shares, the board of directors may dispose of the shares so declined in such manner which is not disadvantageous to the shareholders and the company. The provisions of section 62 are applicable to all types of companies except the Nidhi companies. The provisions of section 62 are applicable to all types of companies except the Nidhi companies. The restrictions contained in Section 62 of the Act regarding issue of further shares do not apply to A. Increase of the subscribed capital of a company caused by the exercise of an option as a term attached to the debentures issued or loans raised by the company to convert such debentures or loans into shares in the company. That is subsection 3 of Section 62. The terms of issue of such debentures or loan containing such an option have been approved before the issue of such debentures or the raising of loans by a special resolution passed by the company in the general meeting. B. Conversion of part or whole of the debentures issued to or loans obtained from any government in shares of the company in pursuance of a direction issued by that government in public interest on such terms and conditions as appear to be fair and reasonable to the government, even if the terms of issue of such debentures or loans do not contain a term providing for an option for such conversion. That is subsection 4 of Section 62. Where the terms and conditions of such conversion are not acceptable to the company, it may, within 60 days from the date of communication of such order, appeal to the tribunal, which shall, after hearing the company and the government, pass such order as it deems fit. In determining the terms and conditions of conversion under subsection 4 of Section 62, the government shall have due regard to the financial position of the company, the terms of issue of debentures or loans as the case may be, the rate of interest payable on such debentures or loans, and such other matters as it may be necessary. That is subsection 5 of Section 62. Where the government has, by an order made under subsection 4 of Section 62, directed that any debenture or loan or any part thereof shall be converted into shares in a company, and where no appeal has been preferred to the tribunal under subsection 4 of Section 62, or where such appeal has been dismissed, the memorandum of such company shall, where such order has been effect of increasing the authorized share capital of the company, stand altered, and the authorized share capital of such company shall stand increased by an amount equal to the amount of the value of shares which such debentures or loans or part thereof has been converted into. That is subsection 6 of Section 62. Next is a case example that is given. Judicial pronouncement relating to further issue of shares by a company. The first case, Nanalal Javed versus Bombay Life Assurance Company Limited. Section 81, corresponding to Section 62 of the Companies Act 2013, is intended to cover cases where the directors decide to increase the capital by issuing further shares within the authorized limit, because it is within that limit that the directors can decide to issue further shares, unless of course they are precluded from doing that by the Articles of Association of the company. Accordingly, the section becomes applicable only when the directors decide to increase the capital within the authorized limit by issue of further shares. The above judgment was followed by the Supreme Court in Needle Industries India Limited versus Needle Industries Newly India Holdings Limited. The court pointed out that the directors of the company must exercise their powers for the benefit of the company. The directors are in a fiduciary position, and if they does not exercise powers for the benefit of the company, but simply and solely for personal aggrandizement and to the detriment of the company, the court will interfere and prevent the directors from doing so. The second case is Needle Industries India Limited versus Needle Industries Newly India Holding Limited. The power to issue shares need not be used only when there is a need to raise additional capital. The power can be issued or used to create a sufficient power of shareholders to enable a company to exercise statutory powers or to enable it to comply with statutory requirements. The Department of Company Affairs, now Ministry of Corporate Affairs, has clarified that 1 year specified in the section is to be counted from the date on which the company has allotted any share for the first time. The third case is Balakrishna Gupta versus Swadeshi Politics Limited. Although the term holders of the equity shares is used in subsection 1A and the members in subsection 1AB of section 81 corresponding to section 62 of the Companies Act 2013, the two terms are synonymous and mean persons whose names are entered in the register of members. The fourth case is in Worldwide Agencies Private Limited versus Margaret T. Dessau. It was held that persons who have become entitled to the shares of a deceased member can exercise all of the membership rights of the deceased irrespective of the fact whether their name is in the register of members or not. And the fifth case, Mathalone R versus Bombay Life Assurance Company Limited. The court held that the transferor could not be compelled by the transferee to take up on his behalf the right shares offered to the transferor, and all that he could require the transferor to do was to renounce the rights issue in the transferee's favor. The fifth point is to check the copy of Form SH7 MGT 14 and file them with the ROC. 6. The shares declined by the existing shareholders can be disposed of by the company in manner which is not disadvantageous to the shareholders and the company. 7. Once the allotment is made, the company shall within 30 days of allotment file with the registrar a return of allotment or in Form PAS 3 along with the fee as specified in Company's Registration of Offices and Fees Rules 2014. 8th one, deliver the share certificate of allotted shares within a period of 2 months from the date of allotment. And the last point, intimate the details of allotment of shares to the depository immediately on allotment of such shares. The next topic is Employee Stock Option Scheme. The term Employee Stock Option Scheme or ESOP has been defined under subsection 37 of section 2 of the Companies Act 2013. Even though it is written subsection 37, whenever it is a definition section, we read it as clause, that is clause 37 of section 2. According to which employee stock option means the option given to the directors, officers or employees of a company or its holding company or subsidiary company or companies, if any, which gives such directors, officers or employees the benefit or right to purchase or to subscribe for the shares of the company at a future date and at a predetermined price. As discussed earlier, Clause B, subsection 1 of Section 62 provides that a company may issue further shares to its employees under a scheme of employee stock option subject to special resolution passed by company and subject to such conditions as may be prescribed. In case of private company, special resolution has been substituted by ordinary resolution. Rule 12 of Companies Share Capital and Divenger Rules 2014. A company other than a listed company which is not required to comply with Securities and Exchange Board of India Employee Stock Option Scheme guidelines shall not offer shares to its employees under a scheme of employee stock option, herein referred to as employee stock option scheme, unless it complies with the following requirements, namely, the issue of employee stock option scheme has been approved by the shareholder of the company by passing a special resolution, exception in case of private company where ordinary resolution is required. Who is an employee for the purpose of subclause B, subsection 1 of section 62? A permanent employee of the company who has been working in India or outside India, or B, a director of the company, whether a whole-time director or not but exceeding an independent director, or C, an employee as defined in clause A or B of a subsidiary in India or outside India, or of a holding company of the company but does not include 1. An employee who is a promoter or a person belonging to the promoter group, or 2. A director who either himself or through his relative or through any body corporate directly or indirectly holds more than 10% of the outstanding equity shares of the company. In case of a startup company as defined in notification number GSR 27E dated 19th February 2019 issued by the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India, the conditions mentioned in subclause 1 and subclause 2 shall not apply up to 10 years from the date of its incorporation or registration. With this, we come to the end of today's audiobook. That is, we have dealt from page 54 to 64. In the next audiobook, we will continue from the remaining. Thank you. Stay safe.